Former President Trump has received a target letter from the special counsel appointed by the Justice Department to investigate the events of January 6th. Trump posted on his Truth Social account accusing the Justice Department of wanting to indict and arrest him. He earlier revealed the letter was delivered Sunday and alleged it instructs him to appear before the grand jury on Thursday of this week. Special counsel Jack Smith is investigating Trump's efforts to undo the results of the 2020 presidential election. He's also leading the criminal case accusing the former president of mishandling classified documents in Florida. Joining us now is Jessica Levinson. She's a CBS News legal contributor and a professor of Loyola Law School, always breaking down the law for us. Jessica, can you explain to us what a target letter is and why it's being used in this case?
A target letter is a piece of official correspondence from the Department of Justice, and it's used essentially to do just what we're talking about today, which is to alert somebody who is the target of a criminal investigation that they are in fact the target and that the investigation is nearing its final stages. And usually, as this target letter apparently did, to say to the person, you can come and testify before the grand jury. Now, the former president has already received 2 of these before, one in a state case and one in a federal case. And in both cases, he said, basically, I'm not coming in to testify. And I suspect that he will not come in to testify before the grand jury in this case as well. But it is the best and clearest indication we have that this investigation is really nearing its final moments. And I think last time we had a target letter from the Department of Justice, that there was an indictment mere days later. So I believe that we're looking at days, potentially weeks, for the next federal indictment of the former president of the United States.
Now, Jessica, I'm just looking at another post from Truth Social where former President Trump is talking about witch hunt, calling the president Joe Biden crooked. I mean, it seems to be yet again one of these cases where he's in legal jeopardy and he kind of uses it to campaign and accuses the president of non-democratic means, something that he says has never happened in our country before. So, I mean, if he decides to appear, perhaps because it could serve him, would it? And what would happen if he does?
So I don't think that he will appear because these letters typically, and we haven't seen this letter, but these letters typically say what you say can be used against you in an official proceeding. The other thing about appearing before a grand jury is that you don't walk in with your lawyer. The letters generally say you can step outside and confer with your lawyer, but you are in there with the grand jury. And so I understand the question was, what if? I just don't think that we're going there, because what you read to me, Lilia, is what he says out of court, but very different what he typically says under oath and in court or in deposition proceedings. So I think in this case, what Jack Smith, the special counsel, has done is talk to enough people in the inner circle that they feel that they do not need that testimony, that they can go forward. That's why there was a discussion with Jared Kushner, the former president's son-in-law, just a few days ago, where they're asking about state of mind, because I think what they're zeroing in on is what the defense's best argument in this case is going to be, which is that he didn't form the corrupt intent to overturn the election.
Yeah, talk to us a little bit more about the facts of this case. What are prosecutors looking to hear from witnesses? What are the main points of the case? Because we haven't really gotten into that quite yet today.
So we don't know for sure, of course, but we think that what the prosecutors are looking at is attempts to overturn the 2020 election. Now, that's broad. We know, of course, that we have to hook that to a specific federal statute. So what are we thinking about? Potentially obstruction of an official proceeding. That would be the counting of the Electoral College votes. We would be looking at another section dealing with defrauding the United States. Potentially obstruction of justice in the investigation. There were some allegations of witness tampering. And maybe there is a provision that we've talked about of the federal code dealing with inciting an insurrection. I believe that all of those are on the table. And to your really smart question here, when we look at those provisions of the federal code, one of the things that prosecutors may have to prove is that Trump knew what he was doing was a problem. And that's why I use that phrase, corrupt intent. And so while Jared Kushner reportedly said, well, the president, I think, really thought he won, we have a lot of evidence to the contrary, and we have Jared Kushner with some credibility issues.
The other federal case against the former president that he was already indicted on, also having to do with intent, or where prosecutors are looking at that, is the one about the classified documents in Florida. Today, there's a pretrial hearing on that case. Walk us through what's happening today.
So this is a hearing where we're going to be talking a lot about procedural issues, not really the substance of these charges, but things like, when will the trial actually be set? We know that there's been some aggressive fighting about the trial date, where the prosecution wants this trial to go forward in December. The former president has said, let's put it out indefinitely. So one of the things that we're really looking for to see how Judge Eileen Cannon, who was appointed by the former president, starts to handle this case is, which side does she lean towards in terms of scheduling this trial? Does she want to move quickly, or does she give credence to the former president's claims that we need to slow walk this? We're also looking at the fact that this case is unique, not just because we're charging a former president, but because we're dealing with classified documents. And there's a federal statute that essentially dictates the exchange of information in cases like this, where what the judge is going to have to weigh in a pretrial hearing like this is, how much information does the former president get? He has due process rights when it comes to our criminal justice system. So on the one hand, we want to protect his due process rights. He's entitled to information from the prosecution. On the other hand, this isn't just any information. It's not a run-of-the-mill criminal case. And we want the federal government to be able to protect classified documents, highly sensitive documents. So that's another thing that she's going to have to start to wrestle with today, that exchange of evidence.
Jessica Levinson, just the excellent law professor, always helping us understand it all. Appreciate your time.
Thank you.